All right, with some final swiveling of the camera completed by our technicians, I think I'm going to get started, even if there are still people coming in online in recognition of the fact that there are people who turned up on time. So thank you very much for joining the Davis Polk workshop on arbitrating Chinese investment and joint venture disputes. What we're going to be focusing on is the challenges involved in handling those disputes, of which I'm sure many people attending have had a significant amount of experience, but equally importantly, learning lessons for use in negotiations and the pre-dispute operational phase of investments and joint ventures. I'm going to guess that most of the people who are participating are on the dispute resolution side. But one of the things that I always tell our team is go and talk to the M&A lawyers, go and talk to the foreign direct investment lawyers, make sure that they understand these things. My name is Martin Rogers. I'm the senior partner of the dispute resolution practice in Asia for Davis Polk, and I happen to be also the chair of the firm for Asia. I'm delighted that Tony Neo, in particular, as well as our other guests, have joined us today. And in a few minutes, I will provide him with the opportunity, which we very much value, of him making an opening short keynote speech. After that, we'll move into the first of two panel sessions, both of which will be moderated by my colleague, John Chang. I'm going to leave it to John Chang to introduce our other panelists. So far as Tony is concerned, besides many other important public and private roles, he is a very active international arbitrator, as I'm sure many of you know. He chairs tribunals which hear major disputes related to China. He's complaining about the number of investment disputes that he's been handling. So he's a perfect person to involve in this workshop, and I'm sure we'll greatly benefit from not just listening to him speak briefly, but also his participation in the panel. Tony is the chairman of the Asian Academy of International Law. He is a very prominent champion of Hong Kong as an international legal services hub. And I really think this topic is important for Hong Kong, given in particular the flow of capital and the presence of the private equity industry and related industries here in Hong Kong. We hope that this workshop and the topics of handling and learning lessons from Chinese investment and joint venture disputes will be very timely. Why? There's an extraordinary appetite for private equity and other forms of investment in China, with growth projections for China continuing, notwithstanding the difficulties, to outstrip every developed market in the world. And the trend being generally, not across the board, for China to open up more, not less, industries to foreign investors. Yet it's clear from our practice, arbitration practice, and I'm sure it's clear from many other firms, that macroeconomic and political factors are generating a significant uptick in problems, and hence a significant uptick in disputes with China investments. In the course of arbitrating disputes for our clients, we can clearly see patterns in the way the underlying problems emerged and how they're handled before the dispute actually turns formal. And those patterns get reflected in challenges faced in either bringing or defending, depending on which side you're on, arbitration claims. Often, a key underlying problem is really basic. It's the failure adequately to assess the integrity of the counterparty, to actually get into bed with and trust the counterparty at all. But quite often it is the documentation, the structure of the investment. It's the limitations in structuring security rights. It's the limitations in structuring the scope and coverage of the dispute resolution provisions. Onshore, offshore investment structures can make things very complicated. And a big issue, which I'm sure we'll touch on a lot, is the lack of personal resource, well, either the lack or the availability of personal recourse against individuals, key individuals, typically the Chinese founders. Very often, though, regardless of structuring issues, the lack of proper exercise of rights, e.g., informational rights, and the documentation, the lack of documentation to show that those have been executed, or decisions have been made to not to use them, but to reserve one's rights. The lack of that documentation during what I call the operational pre-dispute phase of the investment creates challenges. So that is just just a 2-minute overview of the sorts of issues that I would like to see us get into. I'm looking forward to seeing our panels discuss these and other issues. I do have one administrative matter or two administrative matters to mention, both very standard. The first is CPD. This is covered by an abundance of CPD points. We'll be announcing the code towards the end of the workshop in the usual way. The second point, for those of you who are online, is that we do have simultaneous interpreters, English, Putonghua. Somewhere on your screen with the Zoom functionality, there will be something which says something like language interpretation. So look for that button if it's going to be helpful, and you can have the assistance of the simultaneous interpreters that we're using for this. With that, over to you, Tony.
And thank you, Martin. I'm going to take off my mask, otherwise I get really muffled. So, well, first of all, let me explain why I have been complaining about the number of Chinese investment arbitrations that's been coming forward. Now, first of all, I'm not complaining because of these employment opportunities that I have. Who am I to complain anyway about that? But I am complaining because a lot of these disputes could have been avoided, or at least they could have been shortened if there had been adequate preparation. And which is why I find this afternoon's 2 panels to be interesting, and I intend to stay for both, and I hope you will too. But as you all know, that Hong Kong, as an international transport hub, as an international trading center, as well as an international financial center, and there's a massive amount of trading as well as investment transactions going through Hong Kong. And it would not come as a surprise to you that, of course, many of these result in disputes. The question then is, how do we deal with these disputes? The Hong Kong courts, in fact, are not bad, in fact, in dealing with these. And you find these in the High Court cases that have come through. But one of the problems about going to the High Court, although it's cheap, incidentally, you only pay $1,000 actually going to the High Court. I think it's 1,000, but if it's been increased, it's been a little bit more. So it's a public good. But as a public good, then you'll have to ensure that, in fact, you have to observe, in fact, all the niceties and all the I think, prices that you have to pay in using a public good, and which is why people go to arbitration. And I think people go to arbitration if, in fact, one of 6, or at least one or more of 6 characteristics come into play. I think the first, of course, particularly if there's a cross-border element in the transaction, in terms of parties, modes of performance, cross-border payments, counterparties with assets outside the jurisdiction, all of these, in fact, come into play because, of course, if you go to court and you'll find, in fact, once you've got a judgment, you may not be able to enforce it in another country or in another jurisdiction. It's going to be difficult. The next issue, of course, if you come into the glare of publicity in using the public courts, then you have no confidentiality. And the third, of course, is, well, you have to wait in line if you go to the courts. And when time is of the essence, arbitration, of course, is important. And the other thing is this, of course, you don't get to pick your judges if you go to the public courts, but in arbitration, you get to pick your judges, particularly people that you have confidence in their independence and in their quality. And the fifth issue, of course, an important one, is international enforcement. For arbitration, you have, of course, the New York Convention, where 168 jurisdictions have participated in that. And therefore, really, if you do have an arbitral award, then you can enforce in 168 countries. So, which is very, very different to getting an award from a court. And finally, what is important is that if you do have a jurisdiction which is particularly pro-arbitration, which applies international norms, then, of course, you have the confidence, in fact, to arbitrate in that jurisdiction. Now, if I may say so, Hong Kong has all of these 6 characteristics in terms of alternative dispute resolution. And let me give you a little bit of history on this. Now, I was, for all my sins, in fact, the chair of the Hong Kong and China committee. I can say Hong Kong and China at that time because it was 1992. In terms of the listing of X shares in Hong Kong, the question would be, in fact, how do you enforce, in fact, the shareholders' agreements? How do you enforce, in fact, the articles of association? How do you enforce, in fact, the company law issues involved in that? And of course, the UK, which is, of course, then the sovereign in charge of Hong Kong, and China has no reciprocal enforcement of judgment. But one thing they do have is they are all parties to the New York Convention. And as a result, and the UK joined in 75, China joined in 1987. So we're back in 1992 when the X shares came on. So which is why we decided, in fact, to use arbitration as the dispute resolution mechanism. Either you can arbitrate in CITEC or you can arbitrate in HUIC. Now you will find that mechanism actually in Chapter 13 or Appendix 13 of the listing rules. It's still there. We drafted it in 1992. It's still there more or less in the same form. One interesting feature of that is that, well, you can actually start a derivative action if you're a minority shareholder against the majority shareholders in an arbitration. Now, a novel point, incidentally, in international arbitrations, of course, you have that in court proceedings easily, derivative actions, and in fact, double derivative actions nowadays. But then in arbitration, it's still a novelty. So the other thing, of course, is in terms of enforcement, because of the New York Convention in operation in 1992, then whatever is awarded in Hong Kong could be enforced in the mainland and vice versa because of the New York Convention. But after 1997, because we're now one country, so a new agreement was negotiated between the HKSAR and the People's Supreme Court. And that, as you all know, in fact, has been working very well. And in fact, it is now a matter of routine, in fact, enforcing a mainland arbitral award in Hong Kong and vice versa. But then the question would be, are Hong Kong courts, in fact, arbitration friendly? Now, in fact, they are very, very friendly. And if I may then use a few examples to illustrate that point. The first, of course, is that since 2011, the Hong Kong Arbitration Ordinance has wholesale, in fact, adopted the UNCITRAL model law on arbitration. And in fact, whoever, in fact, chooses Hong Kong as the seat of arbitration will actually have the benefit of the oversight of the Hong Kong courts in relation to that arbitration. Now, that oversight, in fact, is very important, and in fact, it helps a lot of people. I would just deal with a few points about that oversight, and I would just deal with 4 areas. The first is limitations of actions. Although you might have a contract which is governed by Chinese law or Brazilian law, as the case may be, if you arbitrate in Hong Kong, the Hong Kong rules in relation to limitations apply. So therefore, really, because limitations is regarded in the common law system as part of the procedural law of the jurisdiction. So that's one thing. The second thing is that if you have an arbitral clause in your contract, and you go to the Hong Kong court to try to sue somebody under that arbitral agreement, the Hong Kong court will stay those proceedings. The Hong Kong will say, no way. And even if, in fact, if you have been dilly-dallying a while, you've been trying to really try and discuss the dispute and didn't sort of do this too often, or rather do this too expeditiously, the Hong Kong courts will still say, well, you know, I look into the circumstances, and even though you haven't been very expeditious in doing that, nonetheless, we will still stay the court proceedings, and you must go to arbitration because you have contracted, in fact, to arbitrate. The other thing, of course, is even more interesting, which is that if somebody tries, contrary to an arbitration clause in a contract, to then go to court proceedings overseas. Now, in those circumstances, in fact, the Hong Kong courts will say, well, you know, you have contracted to arbitrate in Hong Kong, and you can't go overseas, and I'm going to issue what is known as an anti-suit injunction against you. Now, the interesting point is that anti-suit injunctions could actually be issued even against parties who are related, although they're not parties to a contract. What's the reason for that? The other thing, of course, is Hong Kong courts being so pro-arbitration, they would actually look at an arbitration contract to look at the width of the language, in fact, in that arbitration contract. If the width of that language is sufficiently wide, it could actually then really be imported into related contracts in relation to the carrying out of that contract. Now, which sometimes therefore mean that if you have a master contract, and then master contract then says that any arbitration arising out of the implementation of this contract, any issues arising of this contract, you shall go to arbitration. Then you have another agreement which is completely related to this one, and then but then it doesn't say that there's an arbitration clause. Then how do you deal with that? Now, the Hong Kong courts have been applying, in fact, the principles that the UK courts have been using, the so-called Fiona Trust principle, which is when they interpret, in fact, an arbitration clause, they would use probably what I would call a purposeful concept of arbitration, which is to look at really what it's trying to achieve. If that clause tries to achieve, in fact, a settlement of disputes arising from this master contract, then all the related satellite contracts might have, in fact, arbitration clauses imported into them. Now that is a question of argument in every single case. But nonetheless, this principle, in fact, goes back to the clause itself. And you know, I've met many cases where people say, you know, I have to consolidate all of these because even though there is no arbitration clause in the satellite contract, but nonetheless, because of the Fiona principle, you should interpret, in fact, the arbitration clause as to include, in fact, that other contract. The other thing, which is also interesting, you might care to consider, is that really, in terms of agreements to arbitrate overseas in Hong Kong, if you do have, in fact, a third party trying to sue in another jurisdiction, but a third party is so related, in fact, to this particular contract, that the courts would then say, well, you know, you are very related to this contract, and therefore, really, you shouldn't be suing in another country. If you're going to come back to Hong Kong in order to sue, and I would imply, according to the Fiona principle, an arbitration clause in whatever you want to do in terms of suing. Now, a number of cases have actually come through the Hong Kong courts on that. The two cases which I think would be interesting, one, of course, is what we call the Fiona principle and the so-called sort of angelic grace principles, which are applied in the Hong Kong courts. But one recent case, 2019 by Godfrey Lam, which is an interesting case that I thought you might want to read, is called Dixon Valora against Mr. Fan. Now, that's an interesting case because Mr. Fan actually is not a party to any of these arbitration agreements, but then he sued in China. Having sued in China, then Dixon Valora then went to court and said, well, you know, this guy shouldn't be suing in China because he is so related to this contract that he should be, in fact, injuncted from doing that. The courts actually injuncted Mr. Fan in order to do that, and by various legal theories, the first of which is that it is so related, in fact, to the Hong Kong contracts, that I would import, according to the Fiona Trust principle, in fact, an arbitration clause in there. And because of that, in fact, I would assume jurisdiction. Now, the other thing, interesting thing in that case, and something for you to look at in due course, is that Mr. Fan actually got a judgment in China on that. And Mr. Van then said, well, I've got a judgment, so let's reach judicata. And, but then the Hong Kong courts then say, well, if you've got a foreign judgment, which is against, in fact, a contract, which is enforceable in Hong Kong, the courts shall not recognize it. Now, this is part of the sort of public policy common law principle, but there is, in fact, an ordinance in Hong Kong which deals with the recognition and enforcement of foreign judgments. And that ordinance says that if you have a contract in Hong Kong and you try to go to foreign proceedings, and that foreign proceedings, in fact, come up with a judgment which is against that contract, then the court shall not enforce it. Now, this is part of the sort of public policy principle. So therefore, you see that the Hong Kong courts are extremely pro-arbitration. One thing that has happened, of course, since 2019, and which you should be aware of, is that, in fact, a foreign party can come to Hong Kong and ask for interim proceedings wherever that arbitration takes place under the UNCITRAL model law. Now, unfortunately, we do not have a reciprocal arrangement in the mainland until April 2019, when actually an agreement has been reached with the Supreme People's Court that interim measures in Hong Kong by the Hong Kong court could actually be enforced in China. So therefore, really, that has dealt with that problem. And in fact, nowadays, again, a matter of routine, these interim measures. Now, interim measures are very important, as you all know, in terms of protection of property and so on. Now, the question is, if it is an anti-suit injunction, whether or not it would be recognized in China, because an anti-suit injunction is also an interim measure. But we haven't got a case like that so far in China. And that would be, in fact, the next question. I hope this helps. Good afternoon.
Thank you, Tony. My name is Jonathan Chang, and I have the pleasure of moderating this panel today. The first panel will be joined by Tony, Martin, and last but not least, Huawei Sun, who is a partner at the Zhongwen law firm. She's joining us remotely from Beijing. We wish you could be here with us in person today, but we'll settle for this Zoom option instead. Huawei specializes in international commercial and investment treaty arbitrations. She has represented clients in cases conducted under the rules of many different institutions, including the ICC, UNCITRAL, LCIA, SEAC, HKIC, ICSID, and CTAC rules. And she has significant experience working as counsel and an arbitrator in cross-border disputes involving M&A, energy, and resource projects, among others. Why don't we get started then with the first panel, which will focus on common issues and problems that often arise in the context of Chinese investment disputes. In order to focus our discussion, we've created a hypothetical which is diagrammed on the screen, and I will narrate to you. And hopefully after this narration, we'll spend the majority of our time getting insights from Tony, Huawei, and Martin. So what we're going to be talking about during this panel is a situation that I think is fairly common. Imagine we're dealing with a PRC-based technology company. It was founded by two serial entrepreneurs, and over time, they attracted several rounds of investment from both strategic and financial investors. Everyone's goal is to have an IPO launched within 2 years of the last funding round. The operating company is a PRC onshore entity controlled through a VIE structure, ultimately by a Cayman company, and where all the shareholding in this company sits. And to just simplify things, we're not getting into the details and nuance of the VIE structure, but the agreements that we'll be discussing today are the following three, which are also part of this diagram. So the first is a management agreement between the Cayman company and the founders, requiring the founders to devote the majority of their efforts to the company's development and requiring them to not compete with the company for 1 year after they leave or an IPO, whichever is later. The second agreement is a cooperation agreement between the strategic investor and the PRC operating company, which requires the strategic investor to provide royalty-free access to certain products that are important to the company's growth. The third agreement is a shareholders agreement, which captures all the parties within the dotted line you see on the diagram. So that would be the Cayman company, and all the shareholders, which are in groups, the BVI SPVs, where the founders hold their shareholding, the strategic investor, and the financial investors. The shareholders agreement governs the rights and obligations of the shareholders, in particular with respect to making additional capital injections, information rights of the shareholders, and it also provides the shareholders with a redemption right from the founders and strategic investor if an IPO is not launched within 2 years of the last round of funding. Because not all shareholders are parties to all agreements, the shareholders agreement also includes covenants for the founders, BVI, SPVs, to procure the founders to comply with the terms of the management agreement, and for the strategic investor to comply with the terms of the cooperation agreement. So these management agreements, the management agreement and the shareholders agreement, are governed by Hong Kong law and provide for HKIAC administered arbitration seated in Hong Kong. The cooperation agreement, which is between PRC entities, is governed by PRC law without any arbitration clause at all. So the basis of our scenario or hypothetical will be that, let's say we end up in a nightmare scenario. It's 2 years after the last round of funding. There hasn't been an IPO. As it turns out, the founders have lost interest in the venture. One of them sets up another company that begins as a pet project, but over time, the founder spends the majority of his time on that pet project. The other founder ends up becoming a consultant for the strategic investor. The financial investors point their fingers at the founders for breaching their obligations under the management agreement and seek redemption of their shares. One of the founders, the one that went on to the pet project, says the real problem was that the strategic investor poached the other founder, and the strategic investor never followed through on its commitment to provide royalty-free access to the products that were the most important to the company's growth. He also points his fingers at the financial investors, who he claims without justification failed to inject capital after the board issued a capital call notice. So in this situation, we have claims potentially under all three contracts, but not all the same parties are parties to all of the contracts, and there are at least two different potential fora for these disputes. There's clearly a lot of overlap in the factual matrix. And I'd like to kick off the panel discussion by asking Huawei, from an advocate's perspective, if a client comes to you and says, here's this situation, what do we do? Can you share with us some of your initial thoughts? And I'm just, for everyone online, I'm going to stop the screen sharing so you can see the panelists in their full size.
Thank you, Jonathan. It's a very interesting but challenging situation. So among all these parties, I would think that the financial investors who will be keen to exercising their redemption right and recovering the investments with great returns. So the immediate issues are, first, which party they should go after, and second, which forum to go to. HKIAC seems to be the apparent choice, as both the shareholders agreement and the management agreement contain such an arbitration clause. And so for the first issue, coming to the possible respondents, ideally such parties should have substantial assets to enforce against. So it seems from the hypothetical that the founders and the strategic investor, both of them have the obligations to meet the request for redemption. But the hypothetical doesn't say whether such liability is on the joint and several basis. And the challenge is that the founders themselves are not parties to this shareholders agreement. Only their BVA SPVs are. So the first challenge to face is whether we can put the founders as a party, as a respondent party to this arbitration based on the shareholders agreement. I think that we would have some difficulty in proving prima facie jurisdiction over these founders. I will going to let Tony talk about the Fiona Trust principle, but at a face, I think it will be difficult to prove to HKIC that founders should be bound by this arbitration agreement and the shareholders agreement. But strategically, if we are able to find some ways to overcome this jurisdictional hurdle, this will give some strategic advantage to the financial investors because, as Tony just said, there's a mechanism between Hong Kong and mainland that is made possible for the financial investors as applicant in the HKIC proceedings to apply for the interim merits before a PRC court where the founders' property are located. Such mechanism has been widely used in the private equity disputes. So this is the first issue, whether founders can be put as a respondent party to this arbitration proceeding. Coming to the other possible respondents, let's look at a strategic investor. If the strategic investor is an institution, they may have deeper pockets than the individual founders. We know from the hypothetical that one of the founder himself is pointing the figure at a strategic investor. So from the perspective of the financial investors, they could consider claiming against this strategic investor, maybe on the basis of joint and several liability, which we do not know. But at least in the notice of arbitration, we do not need to particularize the basis for making the claim. From the strategic point of view, I think that we can put the strategic investor as one of the respondents on the joint and several liability basis. Then we will be looking at where its possible assets are located, whether it's in mainland China or in Hong Kong or in elsewhere. If we can find the assets, it would open the possibility to make use of all possible tools of these interim measures to put pressure on this strategic investor. These tools would be quite useful in bringing all the parties back to the negotiation table. In many of our cases, I would say that financial investors, they are very keen to looking for ways to have an early settlement so that they could put behind all these issues and move on with other projects. Recent experience, in some cases, we found that for the PRC high-tech companies, they do maintain some offshore accounts in California because of all these offshore structures. So in some cases, it's possible to even go to the US court to apply for the freezing order against the bank accounts held in the US to support Hong Kong arbitration. We have done that for some cases. So these are the possible parties. If I may, I will go to the second issue. So which agreement we should rely on. So in the scenario, we heard that there are 3 agreements that have disputes. In addition to making claim and the shareholders agreement, the next question would be whether it's worth pursuing other claims under the management agreement and the cooperation agreement. I would be hesitant to do so from the PRC's perspective, because it will be provide opportunities for the respondent to raise jurisdictional objections. And because apparently the financial investors themselves, they are not parties to the other 2 satellite agreements. So I would suggest starting the proceeding and the shareholders agreement alone. so that the proceedings can be proceeded quickly without facing other challenges. But even in this situation, there will also be other questions. For example, whether the issues in relation to the other two agreement, whether they can be tried by the tribunal and this shareholders agreement. We could argue that since the shareholders agreement, they have the covenants for the BVI SPVs to procure that the founders to comply with the terms of the management agreement, and also for the strategic investor to comply with the terms of cooperation agreement. So because of all these covenants, the relevant terms of these two other agreements could be incorporated into this shareholders agreement. So these two agreements could be used as evidence to support the obligations set out in the shareholders agreement. So this is what I would suggest to coordinate relationship between the three agreements. And normally to improve the situation, in some scenarios, we can see that in the drafting stage, there will be a provision, a definition called the transaction documents, which would include all these possible agreements. And in the arbitration clause, we can see that it provides very clearly that all disputes arising from all these transaction documents could be arbitrated in a consolidated proceeding. But unfortunately, we do not have this mechanism, this scenario. So we have to rely on some other principles, such as what Tony summarized in the opening, Fiona Trust principle, to try to bring all these issues together in one arbitration proceedings. But in practice, I would see the resistance from the founders if they are based in PRC and if their assets are in PRC, in mainland. Because even if for the financial investor, even if we try to rely on some Hong Kong law principle to successfully initiate the arbitration proceedings in Hong Kong, the PRC founders, if they want to protect their properties in the PRC, they would try to create some troubles. For example, they can go to PRC court to say that there's no arbitration agreement in this cooperation agreement. They can. I see that they are not a party to this cooperation agreement, but they can procure that the PRC operating company to do that in the PRC court. So there's a mechanism before the PRC court, which make it possible for one party to ask the PRC court to confirm the arbitration agreement is not valid, even if such arbitrations take place in Hong Kong. So this is one possible hurdles to be faced in the arbitration proceedings. So that's why that I would suggest we only start proceedings based on this shareholders agreement alone. Thank you, Jonathan, if I may stop here.
Yeah, sure. Thank you very much, Huawei. I want to get Tony's thoughts on this as well, but before, I just want to see if Martin has anything else to add from the advocate's perspective. You can turn on your mic.
To add, I mean, the key difficulty is you want your money back. The business is arguably failing, hasn't been. It's also in any event held through a VIE structure, so you don't have direct equity rights to enforce against, and there is no claim against the founders as individuals, which might be no direct claim, no direct ability to bring them into the arbitration. You've got these BVI SPVs, so I guess all I would add is I would spend a lot of time at the beginning. Looking at and analyzing very thoroughly the available claims, including under PRC law and through the PRC courts. I mean, so far as the founders are concerned, I would ideally want to be going after them. Individually, is there a tortious claim that could be brought through the PRC courts? I would want to examine that. I would be looking at the whether in relation, BVI, is there ultimately going to be a potential BVI insolvency, quasi-insolvency law type claim against the founders if they let the BVI SPVs go down and become insolvent and not honor awards made against those SPVs? I would be looking also, I would be combing through the history of the relationship to look at whether there were representations which were made by the founders which might give rise to tortious claims as well if you needed them. I mean, look, I'm handling a case at the moment where similarly the founders are not individually parties to the main agreement, but it just so happens that there is one of them did sign up to a supplemental agreement, and that, because of the all-encompassing definition of transaction documents which are subject to the arbitration agreement, it looks like we're in the sort of fortunate position where that individual can be sued under the arbitration agreement, and the arbitration agreement covers, the description of the claims that are covered would appear to be wide enough to cover tortious claims. So yeah, I would be very thoroughly looking at the position of the founders before embarking on the actual formal proceedings.
Thanks, Martin. Tony, anything to add from your perspective?
Looking at it from the point of view of an arbitrator, looking at it from the point of view of the arbitrator, I'm very much in the hands of counsel. So, you can't really sort of take the case and run with it. You're a passive body, essentially. But even as a passive body, let's assume that there are free arbitrations going on, and I'll go into why those free arbitrations could be put on foot. But let's assume that they are free for the time being. And any tribunal would then look at, first of all, what in fact is the dispute which represents the center of gravity of the whole thing. And that center of gravity has to be the shareholders' agreement in this case. And the other two would be satellite litigation. The question then would be, how do you then deal with those satellite litigation? And then I'll have to then see how those two other cases, those two other agreements could actually become, in fact, the subject matter of an arbitration. And let's look at the management agreement, which is between the Cayman company and the founders for the time being. Now, obviously, the financial investors are not part of that agreement. So you can't sort of directly then start arbitration proceedings there. However, I mean, there is a piece of legislation in Hong Kong, which of course was started, I think, a few years ago. It's called the Contracts Third Parties Right Ordinance. And that, of course, has been in some US jurisdictions, also in the UK, in many common law jurisdictions, you have actually a contract which actually confers a right on a third party. Although that third party is not a party to that contract, but nonetheless, that third party, in fact, may enforce that contract because of those conferred rights. So you could actually try and start an arbitration in terms of the management agreement, if you want to do that, against the founders, in fact, as a third party right holder. Now, because there is an arbitration clause, and therefore you can start this now. And the reason why it might be helpful to do that is you can then start on foot an arbitration. Once you start on foot an arbitration, then you can actually use the Hong Kong and mainland agreement to actually go to the Chinese court and ask for interim measures in the Chinese court for protection of property. You can get freezing orders against the founders and so on. So that would be one way, in fact, to start those proceedings. The alternative, of course, which is also an interesting alternative, is that you do have a Cayman company, and now, I would presume that the Cayman company is controlled by the founders and the strategic investor, and not the financial investors. So the financial investors are minority shareholders. So you could try, as a matter of Hong Kong procedural law, a derivative action, actually, by way of Cayman company. So in fact, you could actually have two claimants, one actually in the name of the company, the other actually in name of the third party right. to start those proceedings. And you may not win in those proceedings. You may not get a lot at the end of the day. But then in terms of tactics, you might be able to use that as your bridge, in fact, to go into an interim measures proceeding in the Chinese courts. The other one is the cooperation agreement between the strategic investor and the operating. Again, you can say that, you know, as a financial investor, a proper interpretation of that contract is that I am conferred a third-party right. And therefore, you can actually use the third-party right, in fact, again, to start an arbitration, again, to try and get some sort of interim measures against the strategic investor within China, assuming within the mainland, they do have property and so on. So again, tactically, that might be. But in terms of, but then the question would be, is this capable of arbitration? Because there is no arbitration clause in there. And then again, you'll have to use the Valora case, again, to say that, well, you know, because it is so clearly a question of construction of the main contract, this actually implements the main contract. And therefore, really, by the Fiona Trust principle, I should import an arbitration clause in there. But then, even then, the question would be the financial investor is not a party. So the financial investor actually has to find some sort of role in that litigation. And the only way that I could think of at this stage is the third-party rights ordinance. The alternative might be if the operating company were actually a subsidiary of the Cayman company. Now, in which case you're talking about, in fact, a triple derivative action, actually, which of course is possible in Hong Kong under the Waddington case, in fact, decided by the Court of Final Appeal, that you can actually do that. But then the question would be whether that is allowable in an arbitration, a very novel question. And I don't know how to answer that at this stage because the legal theories are complex in this case, and it might be difficult, but I don't think you need to do that. You can just use the contract's third-party rights just to get that as a tactic. Once you actually have these, and you have arbitration clauses, then you could then ask the arbitration panel to see whether you can consolidate those. And there might be sort of common issues of law and fact involved, and you might then be able to consolidate that into one case. But then, you know, is it worth the powder to do that? That has to be left to really a discussion of tactics in that case. But I think it might be worth the powder to do that just to get the interim measures.
Yeah,
I think that's all I'll say.
Okay. Thank you, Tony, and thank you very much. You know, lots of creativity and strategy involved in these decisions. It's very good to get all of your insights on it. You know, one issue that I often see in PRC-related arbitrations now is the overlap between PRC law and the governing law of the contract. So, just building upon the hypothetical. Let's say that one of the financial investors claims it never received the detailed quarterly financial reports that the company is required to provide under the shareholders agreement. And they've launched, that's one of the claims in this arbitration under the shareholders agreement. And the company defends by saying, well, under the new PRC data security law, we're not allowed to give you that information because those detailed informations, are sensitive information, and we haven't received permission from our regulator to export that data offshore. This clearly calls into focus a PRC legal question in a arbitration governed by substantive Hong Kong law. Tony, in this kind of situation, how would you expect the parties to deal with the PRC legal question? Is this something that's subject to arbitration, you believe? If so, should it be handled by way of expert legal evidence or submissions or some other manner? I
think the first question here would be how it would arise in the arbitration. Probably it would arise as a defense. In the arbitration. If it does arise as a defense, then the question would be whether it's a defense which is a good defense, and whoever then asserts that would have to prove it. In order to prove that, then obviously, if it's a question of PRC law, then the usual way is actually for people to put forward expert evidence in an arbitration. But then, the question would be, in an international arbitration, is it absolutely necessary, in fact, for expert evidence to be put forward? And I would say not absolutely necessary. It rather depends, actually, on the issue. If the issue is an obscure one, and the arbitral tribunal really doesn't understand this, then the tribunal would actually have to then say, I really would like to have expert evidence. Alternatively, in fact, if both sides, if the parties agree that this could be a matter of submissions, there's no reason why, in fact, the tribunal would disallow that. So I think at a very early stage of the proceedings, in fact, the tribunal would actually have to deal with the parties. I've actually had one case recently where, in fact, that hasn't been dealt with, and I was rather assumed that both parties would put forward expert evidence. But when the case came for hearing, one side didn't, and the other side did, actually. And I decided, because of the issue itself, because it's relatively plain on the papers, then there's no reason why I can't receive evidence, so long as the parties are not in any way been unfairly dealt with. And I dealt with it on that basis, and then issued an award on that basis, incidentally. But then that's not the best way of dealing with it. I think the best way to deal with that would be actually when the case comes for a case management conference, that this matter be dealt with openly. But nonetheless, it rather depends on the issue involved and whether, in fact, the papers themselves, the law is so clear that you can actually make the distinction. There's another interesting, I digress a little bit on this. And there's an interesting issue here where, for example, in constitutional law cases before our courts, in fact, the Chinese constitutional law is actually proved by expert evidence in our courts at the moment. And the Chief Justice then asked me, do we really need to have expert evidence to prove, our constitutional law to us? But then it's been the done thing so far. And the question will arise in a future case, which is a very, very interesting matter. And again, ditto with an arbitration. I think for parties, and particularly counsel, one actually have to be very, very careful and be alert to this question from the very beginning, and raise it at an early stage of the case management, rather than leaving it at the very end. We were lucky in that case because the issues were clear. If the issues were not clear, then we'll be faced with adjournments and all kinds of things, actually, and that wouldn't be good.
Huawei, Martin, what's your experience been?
Let me go very briefly first, and then let Huawei go. First, as a practical matter, I would try and sidestep the issue, right? Your particular issue there is about cross-border data security restrictions. So I would hope that I'd be advising the clients to say, it's okay, we'll just look at the data, the information onshore. We won't take it offshore. I mean, I'd be looking for ways to sidestep as many of these new PRC laws as possible, and that's coming up a lot in practice. Secondly, yeah, I mean, my experience in arbitrations is that it depends on whether how cooperative the parties are. So I've had cases where the other side has been very, very, strict. I said, no, I mean, typically it's the defendants that, the respondents, they're looking to to put up as many hurdles as possible. So they will insist that it be proved by foreign law. We've had that with tax issues, but we've also had cases where PRC tax issues have been dealt with without the need for external tax advice. I think it does depend to a fair bit on, as you say, Tony, how the parties approach it.
We'll just add one thing, though. In an international arbitration, what is foreign law, actually? We're dealing with laws of every country involved that the contract, in fact, asks the tribunal to rule on. So there's no such thing as so-called foreign law in there, except that it's foreign to the seat. That is all you can say about that. But then the seat, in fact, is the place where you guarantee the procedure. That's all, not the substantive issues of the case. So again, one has to think clearly about that.
Huawei, would you like to share any experience you have on this issue?
Yes, definitely, because this is the issue we often come across in practice. So in terms of this data protection law, I agree that as long as the PRC law issues are framed as a defense to breach of covenants, such issues should be able to be resolved by arbitration, by the Hong Kong Arbitration Tribunal, because under PRC law, there are only very limited circumstances in which a subject matter cannot be subject to arbitration, which typically involves the administrative relationship. Which means the relationship between the civil body or civil individual and the government. But for other commercial matters, all these matters can be arbitrable by the Hong Kong tribunal. And if there's no issue with the arbitration clause, with the validity arbitration clause in the enforcement process, it will be a question of whether any public policy issues would arise from the Hong Kong Tribunal's determination on this PRC law issues. Seldom such a public policy argument could succeed, because Chinese courts are also very pro-arbitration to the extent possible, permissible under PRC law. So this is the first issue. And in terms of how the PRC law issues could be handled, we have different experience. Sometimes when we work with international firm, we would provide PRC law support so that the whole legal team would be able to handle PRC law issues by way of submissions. And if we have the opponent who also have the similar counsel structure, it would be easy for the parties to agree on handling the PRC law issues by way of submissions. In this process, it will be saved the time of having further rounds of expert witness. In practice, it will be 2 rounds, and also the expert conference and a joint list produced by experts. So if we can agree on handling the PRC law issues by way of submissions, all these procedures could be dispensed with, which is a time and cost saving. But in some other cases, if our opposing counsel doesn't have a PRC lawyer in the legal team, sometimes they would argue that PRC law is entirely different from Hong Kong law. So they should be treated as foreign law, and should be handled by way of the exchange of foreign expert reports. Then there will be question whether at a case management conference, we would suggest that the other team, they add a new PRC lawyer in their legal team so that these issues could be handled. As Tony indicated, I think it's very helpful if the parties can openly discuss this issue as case management conference. And if the tribunal is reasonably familiar with PRC law, they may have some tendency or good reasons to think about how to proceed with arbitration. Whether foreign law, PRC law as foreign law would be really needed, whether the proceeding whether it will be beneficial for the proceeding if we have additional time, two months time for handling all these PRC law issues. So this is a question I think need to be discussed at the case management conference and to be determined by the tribunal with some certainty. Otherwise, after the parties make their submissions, there will be another round of argument whether PRC law will be handled by the expert report.
I think
one thing, I was just thinking about that case that I did, for example, that there could be situations where, in fact, you could bifurcate the legal issues, because there's some issues which are clear where, in fact, the tribunal would be quite comfortable in dealing with by way of submissions. And there are issues where the tribunal is not comfortable. I mean, I did another case which deals with town planning law in the PRC, for example. I mean, I'm not familiar with that. And therefore, in that case, we had expert evidence on both sides dealing with town planning. There's a lot of practice involved in that as well. But that other case that I did was really the contract law. And we've dealt with contract law in a lot of cases, and therefore really the material is sufficiently clear to enable, in fact, an adjudication to be made. So again, this requires, in fact, thought, and also requires, I think, the parties to try and sort of make things not difficult as well as not pricey for the parties. I think, we all owe a duty, in fact, to our clients to ensure that, the whole thing is cost effective and so on. And we do have a duty as arbitrators, in fact, to ensure that the proceedings are cost effective. So therefore, really, cost effectiveness questions come into play.
I was going to say the parties seem to be, fortunate that things worked out, having gotten to the hearing without clarity on whether PRC law issues will be handled by way of submission or expert evidence, but perhaps because these were clear and relatively simple issues, that's why they got into that situation in the first place. Yeah, I should mention for everyone in the audience that we'll have an opportunity to do some Q&A after each of the panels. So if you have any questions for panel one, please input, for those online, please input it into the Q&A box in the Zoom function, and we'll have someone passing a mic around for those who are here in person. So the next question I have is, Martin has raised this a little bit in terms of enforceability and the fact that, the founders own their shares through BVI SPVs, which, may or may not be good for the money. In the scenario, assuming, Huawei, that, we've gone with your advice and only commenced an arbitration under the shareholders agreement, it seems like the financial investors' only real recourse may be against the BVI SPVs, based on the founders, their failure to procure the founders to, abide by the management agreement, as opposed to any sort of recourse against them personally. Can you speak a little bit about, enforcement tactics or strategies that you've employed in this kind of situation? And one thing we haven't touched on is whether there's any sort of guarantees provided for under this agreement. How would your assessment of the situation change if the founders had made personal guarantees?
Yes, thank you, Jonathan. This is indeed a very important issue because ultimately the financial investors will be interested in quickly recovering money from the counterparties. For the BVI SPVs, they're likely properties shareholding in the Cayman company, which doesn't sound attractive at all. But we know from this scenario that there lacks direct recourse against the founders individually. So this will bear great significance in considering the overall strategy. So at the offshore, if the battlefield is on the offshore, I think offshore lawyers, as Tony said, there's some mechanism to proceed with this arbitration, even to bring all these three contracts into the consolidated arbitration agreement. There is some legal means to achieve this result. But in reality, if the founder's property is only located in the mainland, the caveat to watch out that ultimately the founders, they can, in the enforcement process, they can challenge the validity of this Hong Kong arbitral award based on that the arbitration agreement is not binding upon the founders themselves. So in the enforcement proceedings, looking at Article 5 of New York Convention, so there is no valid arbitration agreement, then the arbitration award can be rendered unenforceable. So this mechanism has been used a lot by the PRC founders to try to resist enforcement. So that is why that when designing the overall strategy, the important thing is to look at a little bit further, look at enforcement. Because if you have spent a lot of money in all these overseas proceedings, sometimes you only get a paper judgment rather than the judgment, the award that could be really enforced. So that's why in a lot of these situations, in the transaction documents, there will be personal guarantees provided by the founders. If there are such kind of the personal guarantees, it would be very useful to resolve the jurisdictional issues over the founders. So the ideal situation is that the personal guarantees should also contain the same arbitration clause so that they could be either consolidated in the same arbitration or be heard in parallel by the same tribunal. But having said that, personal guarantees sometimes do not work well because all these individuals, they can easily transfer away assets in anticipation of the disputes. So that's why that in preparing for this arbitration, we always ask the client and try to explore with them whether they know any clues of the assets. And often in the disputes didn't happen overnight. There's a long-term process, and sometimes in this process, the financial investors, they would try to negotiate with the founders. So do make good use of this last opportunity to ask the founders to provide some security in the form of the assets they can control. This is very useful in many cases. But in some other cases, even if the financial investors, even if they try to negotiate with the founders, sometimes they don't ask for the security. And in the end, they only revise the contractual term, the payment terms. That would not be very, very useful. So my first advice is try to make use of every opportunity to ask the founder to give you some kind of security. If they try to ask for extension of loans, extension of the payment date. So coming back to our scenario, if we really cannot trace any good assets from the founder, sometimes we need to think creatively. So I would step back to see whether it's possible to work together with one of the founders to claim against the strategic investor. I don't know whether it will be work or not, just to be brainstorming, because we know that the two founders' interests are not entirely in alignment with each other, with one founder becoming a consultant for the strategic investor. So, and also for the strategic investor, they have some issues in claiming against it because the cooperation agreement doesn't have the cooperation agreement doesn't have this arbitration clause. So so I'm thinking if you find out that the founder doesn't have a real assets, whether you'd like to change the perspectives to see whether you can work together with one of them to try to get recovery from the institutions who really have money. So that's the other thing I'm willing to spend some time. Thank you.
Thanks, Huawei. I know, Martin, you recently dealt with an arbitration where personal guarantees of the founders became very important. Can you talk a little bit about, maybe you can't, but to the extent you can you share a little bit about how that can become tactically important?
I think the short answer is I probably can't talk about that particular case. I mean, look, as I said in my, I'm not sure I've got much to add to the commentary I gave right at the beginning, which is that the focus on individuals, can be very important. It all depends on the overall assessment of the sort of matrix of security rights and the availability of assets. But all I can say is it's very important to think very hard about the role of the founders. And I completely agree with the need to think in a versatile way. Potentially, Huawei as always. That's why I love working with her. Kind of covered the bases. You could think about a potential switching the focus of the claims onto strategic investors and their new relationship with one of the founders.
Yeah, I think that's definitely one key takeaway from all the comments during this panel is that there is a lot of room for strategic thinking and trying to identify the key lever on the other side or the other sides, plural, both adversary and who you may be able to enlist to support your cause. We could go on, but I want to make sure that there's time for questions from the audience. If anyone has a question who's in person, just raise your hand. Someone will come around with the mic. We do have one question that I'm very curious about that came in online, and this is for Huawei. Someone asks whether the issue of VIE validity is arbitrable or not under PRC law. Have you ever thought about that, Huawei, or dealt with it?
I think this is a very good question, and this fit into the scenario. But when talking about VIE structure, it's not an abstract concept. The VIE structure is composed by various agreements, and the key agreement is the contract between the WFI and the VIE entity. So I'm thinking that the question is maybe whether this agreement is valid under PRC law. And of course, there are some other corporate documents behind this structure, so that in the end, the revenues generated by the PRC entity can be provided to this WFI through this contractual arrangement, so that all the shareholders in the WFI will benefit from the operating entity. So this is a structure of VIE entity. Because I think everybody knows that many PRC high-tech companies, they adopt this structure to go public, to go listing. And in all these listing documents, there will be some kind of descriptions of this deal structure. And whether it's has been valid or not, I think it happened a lot of time in my cases as backgrounds, like what we have in this case. But I haven't really came across that the validity of such issues challenged by any of the parties in this process. Because often there's some other documents, for example, the shareholders agreement and the SPA, who handled all these substantive issues about a breach of representation and the covenants. So my short answer is this: it can be arbitrated as an interpretation of a contract.
Mm-hmm. So 10 years ago, I arbitrated a case for an international investor who claimed that they discovered that, as far as they were concerned, one of the founders had set up a competing business in breach of various restrictive covenants in the shareholders agreement, the offshore shareholders agreement. They obviously brought their claim for damages, for injunctions. It was an HKIAC arbitration. The primary defense was, it doesn't matter because the whole investment structure is illegal because it's founded on the VIE structure. We put in a ton of evidence. I guess you'd call it both factual evidence about the prevalence of the VIE structure and its history. We put in a fairly academic legal PRC expert opinion. Obviously, our position was that it was valid. A tribunal dealt with the matter in a pretty straightforward way. Valid, not going to, or at least they rejected the challenge to the under PRC law to the VIE structure. They rejected. They went as far as they possibly could. They actually found that, as far as they were concerned, the VIE structure was lawful as a matter of PRC law. They didn't need to go that far. I think all they needed to do was to conclude that the investment structure was not illegal because it was founded on a VIE structure. But obviously arbitration arbitration awards have no precedential value, but you know, for what it's worth.
One thing I might want to add is this: is that an arbitral agreement is a separate agreement to any contract, and therefore, even if the substantive issues are said to be illegal, the arbitration clause is still there, and therefore the arbitral tribunal will have in fact competence to rule not only on its jurisdiction but also to rule on the case as to whether or not its substantive issues are illegal or not. So a VIE agreement is clearly arbitrable. The question would be in the arbitration whether in fact the agreement itself would be held to be enforceable or not. And of course, you know, it rather depends on what issue it is. In terms of VIE structures, I mean, you all know that this arose out of the negative list in Chinese investment law. And the negative list has in fact been shortened tremendously. So many VIE structures which were previously in fact in the negative list no longer there. So therefore, you know, that is no longer a question. The question would be whether there are VIE structures which are still in the present much shorter negative list. And the Ministry of Commerce and the Chinese courts, in fact, probably might take different views on that. But I as a Chinese law question, I wouldn't want to opine on that. But again, one has to bear in mind the separation between the arbitration clause and the substantive agreement itself.
Okay. Well, we'll get an arbitration in front of you in which we force you to opine.
It depends on whether or not you have expert evidence.
We'll agree with the other side not to put in expert evidence. But with that, I want to thank everyone. We've run out of time for panel one, so I want to thank Tony, Huawei, and Martin for the very enlightening discussion. We're going to take a very brief 5-minute break right now and resume with panel two, which will address common issues that we see and look at it from the perspective of how can you protect rights before a dispute even arises. So stay tuned for panel two.
Thank you.
Thank you, everyone. If you could return to your seats, we're going to start with panel two now. So for panel two, we're going to focus, in the first panel, we talked about some of the key challenges and issues that arise once a dispute has come afoot. And in this panel, we're going to work backwards a little bit and bring you back to both the negotiation phase and also the pre-dispute operational phase of the investment to identify the best practices and how to avoid some pitfalls that can be avoided sometimes. And I'm very pleased to have with me on this panel two Davis Polk lawyers, Annie Yan from our Beijing office and Josh Friedman from our Hong Kong office. Annie is a counsel in our corporate practice, primarily practicing M&A law, and she has an extensive experience representing companies and investment funds in a variety of M&A, private equity, and other investment transactions. She regularly advises clients on cross-border securities and general corporate matters as well. And Josh Friedman is a counsel in our litigation department based in Hong Kong. He represents major funds, corporations, and banks in an array of matters in Hong Kong and U.S., including Hong Kong seated arbitrations, U.S. securities litigation, and complex commercial disputes. He also regularly represents clients in criminal and civil investigations and regulatory enforcement actions by authorities in the United States, Hong Kong, and across Asia. So, Josh and Annie, thanks for joining us today. Panel one, we have focused on one hypothetical throughout the whole time. I got some feedback that was a little bit hard to keep all the facts in mind. So thankfully for panel two, we're just going to do it question by question. Hopefully this will be a little bit easier. And just as with panel one, we will also have an opportunity for Q&A at the end of this panel. So feel free to input any questions you might have into the Q&A function in Zoom, or if anyone in person has a question, raise your hand and we'll get to you. So the first question I have for this panel is basically about how to deal with parties, especially, in the last scenario, we talked about founders who ended up kind of not being devoted to the enterprise. So how do you deal with the situation where we're dealing with parties without an established track record? So let's say, we're in a situation where a client comes, I guess, to Annie saying, oh, there's a very promising company, they're doing a Series A financing, but there's a very tight timetable, and we just learned about this, and we really, really like the business, we like the fundamentals, but the signing is just 3 days away. There's not enough time to do diligence on the target or the founders, but the client says, oh, look, we can just, there's all these representations, warranties. What can we? But later on, the investor learned more about the target, after they've signed the investment agreement, and it turns out the target was not as good of a target as the investor initially thought. And that investor would like to get out of the transaction. And just to be clear, it's already signed the investment agreement. So I guess this question is for Josh, really. After signing, what, if anything, can the investor do in this situation?
Thanks, John. It's an interesting question, and one that actually does arise more than one might think, simply because of the level of interest in investments in the PRC at the moment. Is that working? Okay, great. So unfortunately, this is a scenario that does come up in practice. Unfortunately, once the investment agreement has been signed, there are limited options for an investor if they come to have regrets about the target investment. One of the issues that you'll have to consider, and this is one of the, if your primary reliance is on the representations and warranties, will be the basis upon which you've come to have second thoughts. If the basis on which you have second thoughts actually can amount to a breach of the representations and warranties, then you may have a possibility of exiting the investment before closing. But oftentimes there can be real difficulties after signing in determining whether a breach has occurred. After signing, there are oftentimes limited opportunities to do due diligence. Companies typically try to restrict that in order to increase the likelihood of the investment closing. And oftentimes an investor might not have the information rights, might not come into play until the investment has actually closed. So you can be put into a somewhat of a difficult position if you haven't done significant work in advance. And I think this brings up a fundamental question that Martin raised at the outset about knowing who you're getting into bed with, and knowing and understanding who your counterparties are, their big business, and their integrity. And because of the limited options that one has after the investment agreements have been signed, I actually do think that this is a very good scenario to talk about the importance of focusing on the pre-signing process, which is where I believe Annie is going to speak for the next few minutes.
Thanks, Josh and John. So as you know, due diligence is, usually the initial step taken by an investor in an investment or M&A transaction, and it is, very important to do so before an investor signs any definitive agreement. That is, simply because, in the investment process, there are problems of information asymmetry, or even maybe intentional hiding of the true situation from the target company. So, these just adds, material risks to the investor if there is no due diligence has been done before signing the agreement. we understood that in practice, sometimes the parties are under, enormous time pressure to close a deal. But I think they should still take the time to do, certain level of due diligence and to get the documentation right in terms of, allocating the risks identified in the due diligence properly. So anything that is left for for future clarification or depends on the parties' goodwill or good faith may likely to increase any future disputes among the parties. You may ask that why representations and warranties cannot replace due diligence. I think there are mainly two reasons. Number one, the due diligence process normally covers many aspects, including business DD, legal, financial, tax, or other specified areas as needed by that transaction. So sometimes through this process, the investor may identify significant issues, and these can further lead to a few consequences. For example, the parties may decide to change the transaction structure, or the investor may decide to reduce the purchase price or reduce the value given to the target company. And then the transaction documents needs to be further revised to document the risks. And then the investor may even decide to abandon the transaction altogether. So without this process, the investor wouldn't be able to know, whether the scope of the representations and warranties is sufficient or not. And as such, it may be possible that certain material risks are actually left out without any protection for the investor. This is the first reason. The second reason I can think of is that the representations and warranties themselves have its own limitations. The target company, along with the representation and warranty, will deliver a separate disclosure schedule, which is to provide exceptions or limits to the reps and warranties. And the consequence is that as long as a particular matter is disclosed in that schedule, then the target company will not be deemed as in breach of the applicable rep. And the end result is that the related risks associated with this matter is then shifted back to the investor. So, so overall, I think the best protection for an investor is still to conduct, thorough and extensive due diligence on the target and its business as much as possible. And in terms of the legal DD, so in practice, the scope and the level of details of the legal DD will be determined by the particular nature of the transaction. For example, if the target company is a listed company, then there would already be sufficient public information available to the investor for it to evaluate the target. And then at this situation, further DD requesting additional information from target company may be significantly reduced. Or if the transaction is just a follow-on investment, then the DD can be just focus on the period as of the last investment by the same investor. So these can both reduce the scope of the DD, but on the other hand, if the target company is heavily regulated or through certain initial screening, there are certain material risk areas have been found, then it would warrant special diligence targeting these risk areas. That is my initial thoughts. Turning back to John.
Okay, thanks both. So let's just say that the client, the investor has made the investment, but it becomes clear, let's say there's some milestones provided for in the investment agreement. It becomes clear that the target company is not going to meet those milestones. So, the people on the ground, the portfolio managers are discussing with the target management at the company about, alternatives or how they might be able to remedy the situation. As is common in PRC and elsewhere, WeChat and other kind of informal methods of communication are being used. What can be done for an investor to protect itself against a waiver type of argument in a dispute? And I'm curious, Annie, is there anything from your perspective that, prior to entering into the agreement, the investor can do to try to avoid the risk posed by these kinds of normal business discussions?
Yeah, I think at the pre-signing stage, the easiest way to to protect against this type of waiver claim is to include so-called no oral waiver provision in agreement. And such agreement, I think, will typically provide that a waiver of any right or remedy shall not be effective unless it is given in writing. And even if there is, any such waiver given in writing previously, it shall not, be deemed as a waiver of any, subsequent breach or default of any right or remedy. Also, I think the agreement can further add that, any delay or failure by the investor to exercise any of its right or remedy shall not constitute a waiver, and nor shall such delay of waiver preclude the investor from exercising such right or remedy later on. So I think that if these contractual provisions can be clearly spelled out in the agreement itself, then it would be, I think kind of difficult for the company to later on argue that, the company has already waived its rights. A side note that I want to, mention is that, these no waiver and the other clarification language, if they're included, they normally are typically, they're typically in the miscellaneous section, and the parties may sometimes overlook the importance of of these miscellaneous provisions and how important they might be in dealing with a potential dispute. So I think this is something that an investor should be mindful of.
Yeah, thanks, Annie. And how about Josh? From after the signing has occurred, if, let's say, what advice would you give to the investment professionals who are having conversations with the company about modifying some of these targets and deadlines? How do they have those discussions without risking a waiver defense?
Yeah, so I mean, first I would say Annie is completely right. The inclusion of a no oral modification clause in the relevant investment agreements are by far the best measure you can use to protect yourself against any kind of oral waiver argument. And in fact, there's a relatively recent UK Supreme Court case called Rock Advertising that was actually authored by Lord Sumption, who of course sits on the Court of Final Appeal in Hong Kong, and which has also been adopted in Hong Kong, that has confirmed the effectiveness of no oral modification clauses, and actually developed a fairly exacting and tough standard for a party to meet who seeks to overcome and put aside one of these no oral modification clauses and advance a waiver defense. Nonetheless, waiver defenses are very fact specific. And they will introduce some degree of uncertainty in the arbitration process, or at the very least, introduce or increase the cost of the process and the need for discovery and to delve into the record of communications between the parties. And for that reason, I did want to talk about some of the practical tips or things that can come up in part of the operational process that can at least mitigate the risk of one of these waiver defenses, certainly mitigate the risk of one of these waiver defenses being successful, but also mitigate the cost and the uncertainty that these types of waiver defenses can create. Now, I think the use of informal means of communication like WeChat or voice notes has been an issue for businesses operating in the PRC in, really for years. And it's not something that's really new. But I think it's typically thought of in terms of regulatory requirements. How do financial institutions with regulatory requirements meet their retention obligations? But it also is, I think, a real risk from a business and an arbitration perspective, partly for the reasons that I gave a few minutes ago. It can create, when you're having these informal communications, there can be a real risk of miscommunication between the parties that can lead to one of these waiver claims. There's also a real risk that there's not an adequate record, documents haven't been retained in the way that would allow a party to prove whether or not or defend whether or not a waiver has occurred. And I think this scenario can come up quite frequently. So imagine one where if you have an employee who's using a personal device and communicating with a company's management, if that PE fund employee leaves and their messages haven't been retained in some form or fashion, you suddenly have a very big evidentiary gap in what the record of communications with that portfolio company is. And that can create some real uncertainty when you're assessing as a PE company whether or not a waiver has occurred and whether you might have a claim for breach against your portfolio company. It also provides a portfolio company, assuming the portfolio company's management has stayed intact and there's some continuity there, they're going to start the process from a real informational advantage in that they're going to have the full record of communications, while as the PE fund, you are at least to some extent in the dark as to what the full degree of communications might have been between your former employee and the portfolio company. So from a practical perspective, what can you do? How can you advise clients or PE funds to protect against this risk? At an institutional level, there are obviously policies and procedures you can implement in terms of communication policies, the use of non-firm devices. There are also certainly technological solutions you can implement to retain at least some of the messages that are sent through these informal messaging means. The risk is also mitigated, I think, in some respects when you have multiple. I think it's typically the case. Multiple deal team members from a PE fund will be on the WeChat group, so you might have a record from multiple sources. But again, I think there is a risk of the situation occurring where someone leaves and suddenly their records are lost. And so focusing on the policies and procedures and technological solutions from that perspective of how do we ensure that we'll have a record of these communications is one that's worth thinking about. A few other practical tips in terms of how the PE, how the deal team and how the fund employees operate on a day-to-day basis. I think one that's important is to actually think about conducting training with the PE employees, the deal team. I think, in our experience, they are very much aware that these agreements have no oral modification clauses, but they're not as necessarily familiar with how these clauses are interpreted and applied in practice, and what the legal requirements of these policies are. And I really do think that conducting even a minimal amount of training with deal team members to educate them and raise awareness about what the legal standards are with respect to these clauses, and some very basic tips in terms of how to communicate and how to ensure the effectiveness of these clauses in their discussions with portfolio companies could have some real meaningful impact. Certainly, in terms of what the practical tips are. Obviously, I think whenever you have discussions with a portfolio company about modifications to an agreement, whether those are oral, whether they're on WeChat or any other medium, I think emphasizing that those discussions are, need to be documented and need to be subject to agreement in accordance with the oral modification clause. That's important, obviously. From a lawyer's perspective, the best practice, in my view, would of course be after you have one of these discussions to memorialize it in an email to the portfolio company, both documenting what it was that was actually discussed and confirming that those discussions are subject to documentation, in accordance with what your investment agreement requires. That being said, in practice, there is often some pushback from deal team members about that type of recommendation. I think at times, deal team members can often want to maintain very cordial and at times informal relationship or informal communications with their portfolio companies as a relationship matter, and sometimes there is some hesitancy in sending these formal or legalistic type emails to them. Obviously, that's one that needs to be discussed with the deal team and weighing the pros and cons of doing it. To the extent that there is continued pushback, I think other tips that we've shared with our clients and discussed in general are, obviously, if you want to maintain cordial relationships or informal conversations between the principal, meaning the deal team company, the deal team and the management, obviously having parallel communications between the lawyers where it's confirmed that any negotiation or any agreement is going to be subject to contract and subject to documentation, I think is very much important. But certainly, I think even every time after you have one of these negotiations with a client, a memo to file or an internal email confirming what was discussed, while not perfect, still is I think a good source of documentation and record that would have evidentiary value as a contemporaneous document in any eventual arbitration that were to occur.
Thanks, Josh. And I always like to tell clients, just put without prejudice. It doesn't change the nature of your communication too much, but it still makes the point. So we talked a little bit about the increasing importance of PRC law in disputes, and we've seen this year drastic, or some would say drastic, changes in PRC law that have impacted the value of investments in many sectors. I'm kind of curious how or if there's any way to deal with this. If you're a PE fund investing in the PRC, how would you advise them to protect against, major industry-wide changes, like, for example, no for-profit tutoring, or, no kids under, X age playing video games for more than, 1 hour a day or something like that. Annie, do you have any thoughts on how to protect against that from the, pre-investment standpoint?
Sure. I think against this backdrop of the recent, governmental actions, firstly, before an investor makes its decision to proceed with the investment, the investor should still, consider doing a specific exercise, due diligence exercise to, at least evaluate from commercial, legal, regulatory, and other, related perspectives, whether and how the target company and the related industries might be affected by this regulatory update. And if after this exercise, the investor, is satisfied with the result, or the investor finds that, the risk is acceptable, then it can move forward to negotiate with the target company over the details of the transaction. Specifically during the negotiation, I think there are a few things that the investor may want to focus on in order to address these types of regulatory issue. One thing is that the investor may want to consider beefing up the representations, warranties, and covenants given by the target company, which is just to make sure that the target company has been and will be in compliance with these latest regulatory update. Secondly, the investor may want to consider adding certain specific indemnity so that if there is any breach by the target company of these reps, warranties, and covenants, then the investor can get indemnification for its losses arising from these breach. Thirdly, the investor may further consider to shift the regulatory risk to the target company, can through perhaps adding a material adverse effect or MAE closing condition. This basically means that if the target company or its business has any MAE during the period between the signing and closing, then such closing condition will not be able to be satisfied, therefore giving the investors right to just walk away from the transaction without incurring any liability. Also, the investor may consider incorporating the MAE as one of the events to trigger its redemption rights, i.e. to request the target company to redeem the investor's shares so that the investor can get an exit with certain guaranteed return. And this again just leaves the regulatory risk to the target company. But I also, I want to emphasize that, practically speaking, the MAE provision is oftentimes, heavily negotiated, and the company may choose to add a list of exceptions, such as, any changes to the laws and regulations to the MAE definition, and as such, the consequence is that just to disregard the effects or proportionate effect of these exceptions, just for purposes of determining whether an MAE has occurred or not. Those exceptions then shift the risks of regulatory changes back to the investor. So I think this is something that the investor should particularly consider and negotiate with the target company in the context of the current situation. Turning back to John.
Thanks, Annie. Josh, do you want to talk a little bit about how those contractual arrangements may or may not or would play out in an arbitration?
Sure. As Annie talked about, the MAE clauses or material adverse event or material adverse change clauses are a means of shifting some of this the risk from unforeseen events, shifting that risk between the parties. I think in practice, though, material adverse event cases, they're highly specific inquiries. But in practice, they're very difficult to litigate and win. It's effectively an uphill battle to a certain extent. Courts generally construe MAE provisions narrowly, and the standards applied in Hong Kong, as well as other common law jurisdictions, such as the UK and the US, which all have fairly similar standards, are pretty exacting. Generally, a party is required to show that there has been a change or event of such deep significance to the entity that has undermined its financial integrity or really the core of its business, and not merely temporarily, but really in all circumstances and for a sustained period. And to, I think, as an example to highlight how difficult that standard is to meet, when you look at MAE claims during the COVID period, which was undoubtedly an unforeseen event and undoubtedly one of great disruption to many businesses, and really still is a great disruption to many businesses, a lot of MAE claims still failed during the COVID area, because there was uncertainty regarding what the duration of COVID would be. So if it was a fairly short event, which at times people thought it might be, whether that actually qualified, met this duration requirement of an MAE event. Now, depending on the type of change in law event that you actually see in the PRC, it might create real questions as to whether that constitutes a material adverse change or a material adverse event. Certainly John, I think, brought up too earlier, and something like the prohibition against for-profit tutoring that effectively eliminates an industry or eliminates a business. That's I think the type of issue that at least depending on the terms of the clause and other fact-specific questions, there'd be an argument that might constitute an MAE event. When you have other change in law events that, for example, limit the amount of time someone can use your product in the case of the video game restrictions, or that make it more difficult, or that add administrative burdens, the question of whether those might constitute MAE events are it's really more questionable. But the general thrust of this, as Annie mentioned, the material adverse event clauses are highly negotiated, and these days will typically include a significant number of exclusions or clauses identifying what types of event or what types of impact on the company need to have occurred for the MAE clause to take effect. Given the risk of additional regulatory or legal changes in the PRC going forward, this is the type of clause that one really needs to focus on, and one really needs to try to anticipate really the worst case scenario type of change in law events that could impact their business, and what the likelihood of that triggering an MAE clause might be, but also considering the range of other restrictions that might be implemented, and how you're going to incorporate or reflect that into an MAE clause, and how you're going to balance the risks between the parties in the relevant investment agreements. It's really, I think, an interesting question that is going to develop further in this region.
Yeah, thanks, Josh. Certainly, this is an area that we'll all be watching very closely. Just a reminder to those online, if you have any questions for these panelists, please put them into the Q&A function in Zoom, and we can reserve some time to address those questions. So one issue that came up a lot in the first panel was enforceability, and the situation where you're dealing with the VIE structure, and the private equity investment is in a contract with an offshore company which holds very little or no assets beyond shares in another company which ultimately holds the right to a contract. What can be done to protect the investor's position here in the event of a dispute? And I guess, Annie, can you talk a little bit about kind of the pre-signing process in terms of structuring the right parties to the contract, and what would you like to see ideally to protect investors' rights? Annie, I think you're on mute.
Sorry. I think there are a few suggestions to the investor at the pre-signing stage, to help with the, future recovery and enforcement. I think first of all, considering the Cayman company is just a holding company, without any operations and any particular assets, I think the investor can, request that the founders of the target company shall be jointly and severally liable for the company's liabilities, such as the company's liability to pay the redemption price to the investor. I think through this arrangement, the founders will be held personally liable, and this can, basically put more pressure on the founders, so that they will make efforts to cause the company to fulfill the obligations. This is one thing. Also, we have seen cases where the investor has, specifically, bargained for a more enhanced protection. For example, they may require, the founders to, to pledge their shares in the target company to the investor, which is just to secure secure the performance of the agreements. I think this can, certainly be helpful to the recovery by the investor. But it is in practice, hard to get, and I think the founders may strongly push back on this request. Finally, I want to mention that if the investor's claim is to request for redemption of the investor's shares in the offshore holding company, if it is commercially practical or feasible, when the investor negotiates the agreement with target company, the investor can further improve its rights, by adding certain additional requirements, such as requiring the company to set aside certain cash reserve for purposes of paying the redemption price, or allowing the investor to cause the company to perhaps borrow money or sell these assets, or have the onshore subsidiaries distribute dividends up to the holding company, so that the holding company can have the money to pay the redemption price. I think these measures can further increase the investor's chances to collect the outstanding amount owned by the offshore holding company. But again, these provisions in practice still require certain kind of cooperation by the target company.
Thanks, Annie. How about? Yeah. Thanks, Annie. Josh, do you have any thoughts from the post-signing perspective?
Well, I mean, I would say, I think the first panel discussed issues with enforcement quite a bit. Tony certainly mentioned the mutual recognition of arbitral agreements in various jurisdictions, including in the PRC, and Huawei and Martin discussed some of the strategic questions in terms of enforcement. So I don't want to rehash that into the enforcement process too much. I think since we're focused on more of the looking back aspect in this panel, I would maybe say that one important question is to always look at the nature of the business of the target company, and to think about your enforcement mechanisms from the outset. And depending on the type of business that the target company is engaged in, it may be a very different scenario. For example, the assets of a international tech company that may have operations or accounts globally will present different enforcement challenges than a PRC advertising agency, where a lot of the value may be caught up in personal relationships of the founders and the management team, and the goodwill that they bring to the table. Similarly, different enforcement challenges will be created if you have a PRC mining concern that has very tangible physical assets, but are located in the PRC. So I would say that in the process of negotiating the agreement, it's very important as counsel to think through, and I think Huawei raised this in part during her discussion, is to think about where the assets of the target company are, where you might be able to recover from, and to think about who the parties are that hold those individual assets, and to really do a little bit of a desktop study or a desktop analysis in terms of how you would go about the enforcement process if worse comes to worse and it's actually needed. Yeah. Maybe I'll leave it there.
Thanks. That's often a thing that we do when a client comes and says, "Hey, we have this dispute." We look for where are the assets, who are the targets. And Annie, earlier you mentioned due diligence and the importance of due diligence. Is that type of diligence ever done in the pre-signing stage? Looking into the availability of assets. Who holds what in what jurisdiction? Do the founders hold assets in their own name or in their spouse's name or some other unrelated third party's name? Can you shed a little bit of light on those issues from your perspective?
Sure. So on this perspective, I think in terms of the due diligence process, typically the parties will first, decide, what is the transaction structure. If the target company, is just a holding company structure and then has the VIE structure, it perhaps warrant, certain mechanism, as I just mentioned, adding certain protections to the investor, saying, not only having the holding company without any assets being the primary party, but also adding the founders to the game, and asking the founders to be part of the obligations. And also in terms of the founders, I think normally the parties will be, before going into transaction, they will probably doing certain background check on the founders, and also in terms of whether the founders has been any violates any laws and regulations before, this type of credibility, etc. So I think these are the types of typical diligence that parties may want to consider before doing a transaction.
Thank you very much. I just want to take a moment and ask if there's any questions from the in-person audience. Yes, sure, Tony.
Thank you very much. Very, very interesting presentation. I just have a practical question here, because I was looking at the first panel, and the idea has crossed my mind that if I couldn't get my money back, I'll have a go at the lawyers. Particularly, looking at firms which might be perceived to have deep pockets. And the question then is this: is nowadays legal business extremely competitive, and you have to basically pitch for the job, and therefore really give a quote which could comprise everything. And the very good practice that you have just outlined to us, which I consider to be extremely good. The question then is, how far can you go in order to do all you can within the constraints of the quotation in a highly competitive legal business? And how do you protect yourself in those circumstances?
Annie, to the extent that this covers part of, I would think, the M&A mandate, would you like to go first?
from the M&A mandate, I think
maybe I can talk a little bit as someone who dabbles in law firm defense work. I think that, and actually I've dealt with a case where a client sued. They were in a situation, it was a lending transaction. There was a secured loan backed by inventory. They did what Josh was saying, right? They looked at what are the assets backing up this investment. It's inventory. So we're going to get a lien on the inventory. But what happened was that the inventory was not worth what the client thought it was. So they turn around, they went through bankruptcy processes, tried to recover as much as they could, and then finally turned around and said, hey, our law firm has a very generous insurance policy, very good coverage. Why don't we sue them and, we can recoup some money. And basically the whole case became, was it part of the lawyer's job to do due diligence on the value of the inventory or not? The lawyer's position obviously was, look, our job was to get a lien on the inventory. You had the lien on the inventory, and whether that lien was able to recoup the value you intended or expected, that's a business issue. That's a financial issue. It's not a legal issue. We ultimately prevailed, but it was much messier than it needed to be because there was no clear delineation. In for example, in the pitching process or in giving the advice, there was no clear advice saying, all right, this is our role. We are assuming this is your role. Our advice is X. Based on these assumptions, or based on our understanding that you've done the diligence on the financial aspects of the deal. Blah, blah, blah. I mean, obviously, a lot of these things are much easier said than done, especially, the first scenario we talked about was the investment window. The client has 3 days to decide whether to sign this deal or not. And sometimes, if a client loves a deal, there's nothing that's going to stop them from doing it. And, if you recognize as a legal practitioner, if you recognize that you're in one of those situations, you really need to think about how do I best document the limitations and restrictions under which the client has, essentially forced me to operate under, while still maintaining a positive relationship with the client. And there are ways to do that. It's a little bit beyond the scope of this panel, but thank you for the question, Tony. I think with that, we've come to the end of our substantive portion of the event. I hope everyone's found the discussion very informative and interesting. I know I have. I've learned a lot from all of the panelists. And I especially want to thank all the panelists, especially Tony and Huawei, for joining us. Their time is very valuable. I know Tony last week told me he has a very busy week, so I thought, oh, he's attending Hong Kong Arbitration Week events. And then in addition to that, he told me he has 2 board meetings this week. So we're very appreciative, Tony, of your time and the energy that you've devoted to this panel today. For those who are interested in CPD credit, the code is 026. That's 026. And for everyone who's here in person, you're welcome, and we really hope that you'll stay for a while to join us for our networking session, where you'll get a chance to meet and mingle with everyone in the room. Thank you again to all the panelists, and thank you everyone for attending.